Is AI cold calling legal? B2B and B2C cold calling laws? US and more. AnyBiz. In an era of digitalization, many companies still rely on phone calls to connect with new clients. Over half of senior executives prefer phone communication for updates and business ideas. However, this preference comes with complex regulatory requirements. Knowing the legal landscape of cold calling is crucial for any business, whether a US multinational or an Australian startup. This video will help you navigate the regulations concerning B2B and B2C cold calling in the US, UK, Canada, and Australia, ensuring your strategies are both successful and legal. Cold calling allows companies to reach potential clients who haven't previously shown interest in their products or services. B cold calling involves businesses communicating with other businesses to set up meetings or build long-term relationships. B2C cold calling targets individual consumers for quick sales. The Federal Trade Commission's Telemarketing Sales Rule, TSR, governs cold calling in the United States. The TSR outlines what companies can and cannot do to protect consumers from abusive practices. B2B cold calling is generally less regulated, but B2C cold calling requires adherence to strict rules like the National Do Not Call (DNC) registry. The UK's Privacy and Electronic Communications Regulations, PCR, oversee cold calling to ensure privacy in electronic communications. B2C communications need explicit permission before marketing calls are made, while B2B communications are less regulated. The GDPR also impacts cold calling by requiring clear documentation of consent. Canada's anti-spam legislation, CASL, targets spam and electronic threats, requiring consent for commercial electronic messages. The National Do Not Call List, DNCL, specifically regulates voice call telemarketing, making it essential for businesses to check this list to avoid penalties. Australia's Spam Act 2003 mandates that unsolicited commercial messages can only be sent with the recipient's permission. The Do Not Call Register. Act 2006 allows people to register their numbers to avoid telemarketing calls. B2B communications are not subject to the Do Not Call Register, but must comply with consent and unsubscribe provisions. Obtaining consent is the cornerstone of legal cold calling. This involves clear communication about the nature of future calls, keeping records of consent, and providing an easy way for customers to withdraw consent. B2B and B2C cold calling consent requirements may vary based on local laws. Effective record keeping is vital for demonstrating compliance with telemarketing laws. Businesses should document client contacts, consents, and communication preferences. This helps protect against complaints and enhances the efficiency and reputation of calling operations. Training telemarketing staff in legal and ethical communication strategies is essential. Employees should understand how to obtain and record consent correctly and be aware of legal boundaries. Proper training ensures compliance and fosters positive customer engagement. AI automates cold calling tasks while ensuring legal compliance. It verifies consent, adjusts scripts to align with regulations, and enables personalized interactions at scale. In both B2B and B2C scenarios, AI predicts compliance issues and analyzes calls in real time to maintain adherence to standards. AnyBiz transforms lead generation with multi-channel strategies and upcoming AI cold calling. It offers extensive customer data, automated campaigns, and AI-driven lead nurturing for effective engagement. Prioritizing compliance and effectiveness, AnyBiz is the ideal partner for business growth. Just before you go, take a moment to show your support. Give us a thumbs up and hit subscribe to stay in the loop with our latest releases.